Good morning. Welcome, everyone. I am Teresa Weeks. I am a personal line sales consultant with Cowan Insurance Group. We do offer group home and auto programs for chamber members. Today, I'd like to welcome Megan Swan. She will be speaking today. Megan is a partner at Pavey Law, where she heads up at litigation practice. Megan joined the firm in 2015, having practiced with a large Toronto firm as a partner in its litigation group. She has in-depth knowledge of employment law and advises both employers and employees on all matters relating to hiring, workplace matters, and investigations, terminations, and accommodation requirements. In addition to her employment law focus, Megan provides general corporate commercial litigation advice to clients, which includes matters ranging from shareholder disputes, breach of contract, construction liens, and breach of fiduciary negligent matters. Since moving to Cambridge, Megan has also become an active member of the community and serves as a director of the board of the Cambridge YWCA and is a past member of the Cambridge Shelter Corporation, the Bridges Board. She also serves as the president of the Cambridge-based Shades Mill Law Association, which provides continued legal education opportunities to local legal professionals. Welcome, Megan.
Thank you, Teresa, for the warm welcome. And thank you, everyone, for joining me today. When I was asked to first do this presentation, it was back in July of last year, and the topic was, at that time, hiring after a pandemic. Unfortunately, the topic is a bit modified to say that hiring after and during a pandemic. So we are now currently back into a modified step 2 of the provincial roadmap, unfortunately. And so we're having to deal with additional restrictions and requirements in Ontario, which obviously affect many employers and employees, considering the types of restrictions that are being imposed. So today we're going to go over a few topics. If you could do the next slide. So the topics for our discussion today, we're going to focus on first on an employment contract. So when we hire in Ontario, it's always my best advice is that when you're hiring is that you actually enter into a written employment agreement with your employees. And that employment agreement will outline various rights and responsibilities, but the ones that we'll touch on today that are most important are termination clauses, a clause regarding temporary layoff, and a clause regarding unpaid leaves of absence. And we're going to talk about those today because those are the ones that I have been dealing with most throughout the last year and a half during the pandemic, that when an employer comes to me and has questions regarding what they can do with their employees during the COVID pandemic, we often have to touch on those particular provisions to see what are the rights and responsibilities. We're also going to talk about bringing employees back to work. That could either be back to in-person work if your employees were working remotely in their homes, as well as back from a temporary layoff if that is still being imposed. The other thing that basically was most of my focus for the last part of 2021 was talking about vaccine policies. Many employers did decide to put in a particular type of vaccine policy. And we'll talk about the different types of policies that employers have put in place and can going forward. And we'll talk about a little bit about what we're hearing from the courts regarding vaccine policies and whether or not they're going to be upheld. So we'll move on first to the first poll question that we have for today. My question is for those participating is, do you have a written employment contract with your employees? So if anyone could, I've got one answer so far. If you'd like to participate, I'd love to see the difference between participants, whether or not they have written contracts or whether or not it's just an oral contract. Okay, well, it looks like the majority, 71% so far, do have written contracts, so that's fantastic. We'll see now going into the contract if we can go to the next slide, whether or not the contracts have particular clauses in them that would be most appropriate right now during a pandemic. And the other question that I had was, have you had that contract reviewed since 2020? And the first point on this particular slide that is important is this termination clause. We had a case called Waxdale that really changed the requirements regarding termination provisions in a contract, and that unintendedly has now created a contract that could be invalid with respect to termination, where previously it was valid. And so what the courts are doing is they're going to be looking at the termination sections as a whole to determine whether or not they are enforceable. And if one of the particular clauses is unenforceable because it doesn't comply with the Employment Standards Act, then the entire termination provision will fail. And in that case, it was regarding a just cause termination provision, which was a little bit more expansive than what the Employment Standards Act provides, and therefore was unenforceable and created a whole host of problems with a valid termination provision. So because of the pandemic and because of the continuation of the pandemic, many employers have either had to reduce their workforce. And so not on a temporary basis, but on a permanent basis. And so going forward, when we're hiring new employees, it's really important to have a written contract that clearly sets out the termination requirements and entitlements to employees, and to clearly limit your employee to only the minimum standards provided by the Employment Standards Act. So those minimum amounts of notice or termination or pay in lieu of notice upon termination are significantly different than what we call the common law reasonable notice. And so it's important that you have a contract that sets out, what you will be required to provide to the employee upon termination. And it has to at least be that minimum standard. It could be more. It could be a formula that captures at least the minimum plus some. But it needs to be clearly outlined that what an employee is getting is satisfactory when we compare it to the Employment Standards Act, but also is less than common law. Some employers throughout the pandemic came to me because they did have to reduce their workforce, and without a valid contract term regarding termination, they had to then consider what the employee's potential common law reasonable notice would be. And in that situation, the courts will look at the person's age, length of employment, their skills and qualifications, and the general availability of alternative work in the marketplace. And so those factors will often create a much higher liability or period of notice for that particular employee than what the ESA provides. So that was one big thing throughout the pandemic, that with both the Waxdale decision and the unfortunate requirement to reduce labor, that employers were looking to make sure that they have a contract that has a good termination provision to decrease the amount of notice that they have to provide. And so the one thing that really came up, which we never really had to deal with before, was a temporary layoff clause. Typically, most employers will not have to place an employee on a short-term layoff pre-pandemic. Usually, temporary layoffs were for more of a manufacturing setting where work was cyclical and could stop at any time, and then needed to have the ability to bring on people, put them, and then take people off, and then bring them back again. We now know that pandemics can happen, and that a temporary layoff clause is needed and has been employed by a lot of employers during the pandemic. We have seen that throughout the pandemic, the government has stepped up and changed the terms of the Employment Standards Act, because previously, if you kept someone on a layoff over the particular period of time that's allowed for under the Employment Standards Act, that would at some point trigger either a dismissal or the employee could claim constructive dismissal because their wages and hours were reduced. The government has deemed that anyone that has been placed on a temporary layoff during the pandemic as a result of COVID is now deemed to be on what's called an infectious disease emergency leave. Now, that is a leave and a deemed leave under the Employment Standards Act, but we have different court decisions on what the effect of a temporary layoff. And what we have heard from the court, there's been conflicting cases. In one instance, an employer had to lay off a particular employee as a result of a closure. That employee said, wait a second, you can't place me on a temporary layoff. That's not a term in my contract. I don't have that. We don't have an agreement that you can do that. So although the Employment Standards Act allows you to do that, the case law prior to the pandemic said that if there is no written term to place someone on a layoff, then that employee can still claim constructive dismissal. A constructive dismissal, it means that if you materially change a significant term of someone's contract. So what's significant about a term of an employment contract is I get to work and I get paid for my work. If that employee doesn't get to work and is not paid to work, then that is significant and it's a significant change. And so in that one case that we have from actually local Kitchener court was that that employee who was placed on a temporary layoff, because that employee did not have a term of their contract that said that the employer could lay them off, that was deemed to be a constructive dismissal. Now, we have had a Toronto case that said, well, wait a second, no, when the government made this infectious disease emergency leave regulation under the Employment Standards Act, it took away the employee's common law rights to claim constructive dismissal. We do not yet have a Court of Appeal decision, but most employment lawyers are leaning towards the fact that if you do not have in your contract a provision that says that that employer can place someone on a temporary layoff, then that will be deemed to be constructive dismissal. Now, there's also been some commentary recently to suggest that after a point of time, if an employee has been on a temporary layoff and at no time has said, no, I don't agree with this, and I'm going to be deeming this as constructive dismissal, at some point, the court will say that they've accepted it. They've accepted the temporary layoff, and that has now become a term of their contract, that this is no longer an ability for them to deem this as constructive dismissal. So I do have lots of employers who've had to place people on a temporary layoff who did not have a temporary layoff clause in their contract. And many of those employees did not dispute at the time of a layoff that it was constructive dismissal. And if those employers are still on a temporary layoff up until this point, it is likely that a court will say, well, you've already agreed by your inaction that this was permitted and it's now a term of your contract. But if people are going to be, employers are going to be hiring on new employees going forward, it's very important to make sure you have this clause in your contract, because if you decide that you need to lay off someone on a temporary basis, you don't want that employee to immediately say, no, I'm deeming this as a constructive dismissal. And when a constructive dismissal happens, that means the employer is required to provide an employee with the notice that they would have received had it been an employer initiated termination. So we're trying to limit the liability of an employer by including these new clauses in a contract that otherwise would not have been usually used in a typical contract of employment. The other thing that's important to talk about in an employment contract is an ability for an employer to place an employee on an unpaid leave of absence. So, and this has become important when we're talking about COVID vaccine policies, because some employers have decided, and we'll get into that a little bit later on, but that one of the disciplinary measures that they're going to impose if an employee does not comply with a vaccine policy is to put them on an unpaid leave until they do get vaccinated. And so putting someone on an unpaid leave of absence because they are not allowed to work and not being paid is also a significant change or a material change to a provision of their employment agreement, either oral or written, that they're allowed to come to work and they're allowed to get paid. So again, with the vaccine policies, some employees are claiming that if they've been placed on an unpaid leave of absence, then that's constructive dismissal. So we want to make sure that in a contract, we are, when you're offering new employment to someone, that they understand that if they fail to follow an employer policy, or if there is a need to impose discipline, that one of those discipline measures could be an unpaid leave. If it's not specifically stated as unpaid, then the employee could claim constructive dismissal. So we want to make sure that we're covering off those bases. So we'll move on to our second poll question. And that question is, did you implement remote work during the pandemic? So I'd like to see kind of from our participants whether or not that was an option or something that was put into place. So you'll see the second question is, do you have a remote work agreement? Let's just ignore that. We'll just talk about remote work agreements. But it does seem, again, we're getting to the 70-30, that most people were required to implement some sort of remote work requirement. Okay, now we'll go on to bringing employees back to work. So this might be a little bit premature considering what we're currently facing, bringing people back to work, but most employers that I talked to during the pandemic, especially late in the year last year, did have people coming back into the office space and returning somewhat to normal operations. What's important regarding remote work is at the time of having to impose the remote work situation because of the lockdowns or restrictions, is did the employer communicate that remote work would be temporary in nature? The concern with remote work is that after a period of time, and it's consistent, so if someone placed an employee on remote work since March of 2020 and said, okay, you're working from home, but didn't really say, okay, you're working from home as a result of the measures. Once we're able to safely return to work, once vaccines have been rolled out, you will be coming back into the office. Some people, some employers have come to me and said, well, now I'm trying to bring people back into the office, but they don't want to come back. And so they've asked, can employers order employees back to work? And so, yes, employers do have the unequivocal right to force employees back to work and declare that they have abandoned their job if they don't return to work. However, that's prefaced on the fact that it's been clearly communicated to the employee that this is temporary. It's as a result of the pandemic, and it's not a term of employment. What employers can get in trouble with is that if they've hired within the pandemic or during the pandemic, and that employee has started off their employment in a remote work basis, was it communicated to that employee who never worked in an office environment or within the business's physical location? Was it communicated to that employee that at some point they would be having to attend the workplace? And that's where it can get tricky, is that if that was not communicated clearly to the employee. Now, again, the risk of permitting continued work in a remote manner is that if you permit workers to work from home much longer than practically needed or legally necessary, meaning lockdown, it will become a term of their employment, that this is going to be something that they will be expecting to have the ability to do that. And if you then order them back after an extended period, or after, it no longer appears to be temporary in nature, an employee could claim constructive dismissal because you're changing a material term of their employment. And back in the end of 2021, I would say that we're reaching a bit of a tipping point. We had the vaccines rolled out, people were returning to work. Now, my opinion kind of changes now, because we're back into another situation of closures. And so we're back into another, requirement that people work from home, so long as they're able to do so. Now, do employers have a policy regarding remote work, and then a plan to bring them back? So again, the plan is do it at a point where it's no longer necessary or legally required, so that it doesn't become a term, if you haven't yet already communicated that it's temporary in nature. And then a policy regarding remote work. Those policies are becoming much more needed now that employers have found that sometimes remote work is productive. It is an option available to certain employees, depending upon their role, of course. But we need to make sure that we have a policy in place that clearly outlines the rights and responsibilities and obligations of both parties. And so we need to focus on, how performance is going to be evaluated for at home work. Details regarding expectations while working from home, details related to hours of work. There's an issue of cybersecurity and confidentiality. So depending on what type of work the employee does for you, you want to make sure that the electronic means are going to be, the computers that they're working on, the programs they're working on, antivirus, all of those things to ensure cybersecurity, as well as maintaining confidentiality depending on the work and information being shared. And one of the biggest things that has come up during this entire pandemic is this right to disconnect from work. So, people have been working from home, and the hours of work get a little bit muddied. And so that is something that you would want to put in your policy as well, is that, what are the hours of work that you're requiring the employee to be on during the day and engaged with work, or are you offering flexibility? Now, if you're offering flexibility, we now are having to consider this new Working for Workers Act that provides an employee the right to disconnect from work. And so that act is coming into force. So it is in force now. Employers who have employees of 25 or more will have to have a written policy in place that details the employee's right to disconnect from work at any given time. And this doesn't apply to just remote work, it applies to all work. So even in an office environment, if someone's regular hours of work are 9 to 5, but they're getting emails or calls that they're expected to answer or respond to after those hours, then they're going to be in violation of this new requirement to disconnect. So you have to figure out, what is the standard hours of that person? Do they vary? Are the standard hours required of them to be answering out of office, out of office hour inquiries? So this policy does need to be in place. Employers have a grace period until June 2nd of 2022 to determine the amount of employees they have as of January 1st of this year, and have a policy to disconnect by March 1st of this year as well. We don't have yet any guidance regarding any exemptions from this policy. It is expected that there will be some sort of exemptions under the Act, under the Employment Standards Act, that will provide that certain professions will not be, that this policy will not be applicable to certain professions. There are currently lots of exemptions under the Employment Standards Act, including like legal professionals. We don't get the same protections or rights as other employees. And so we expect that likely there will be some exemptions from a particular category of employee. So we're waiting to hear on that. Okay, let's go to the next poll question. This has been a big topic of conversation in the media with lots of my employer clients, but has your business implemented a COVID-19 vaccination policy? Looking like we're still looking around 64-36, a little bit less on this one percentage wise regarding vaccine policies. So 63 of the participants have implemented a policy and 38% have not. So let's go. Should I implement a COVID-19 policy and what type? This has been a hot topic. Now, the first one, mandatory policy with exemptions. So the mandatory policy that has been rolled out specifically in the healthcare sector. So the government, made a policy directive that required hospitals, long-term care homes, et cetera, to implement a policy regarding vaccines against COVID-19. And many of those organizations and institutions decided that they were going to make it mandatory. So everyone in the workforce has to get to be fully vaccinated against COVID-19 unless they have an exemption. And the exemptions that are available to certain are available under the Ontario Human Rights Code relate to religion and a medical. Now, we didn't hear a lot, and we still don't hear a lot about religious exemptions when it comes to our own personal vaccine passports in order to access different services, restaurants, etc. But employers needed and still need to consider whether or not their employees may have a religious reason that would prevent them from obtaining a COVID vaccine, or have a medical reason from obtaining a COVID vaccine. We do have very clear guidance on the medical exemptions. College of Physicians and Surgeons of Ontario, we're very good at outlining that there are very few reasons why someone cannot receive a vaccine as a result of a medical issue. And a lot of the employers that I've been working with, when we create a policy, obviously we outline that there are exemptions, and religion and medical are one, but we get the employee to complete a form that indicates that their physician has signed off and has read that, the very narrow reasons for permitting a medical exemption, and then they sign off that they recognize that this medical reason falls within one of the categories, and then they also provide a time period in which that medical exemption is applicable. And so those are pretty straightforward because we're dealing with physicians who have, their medical license on the line and who are, trained to give that opinion regarding vaccine. Religious is very different. And it's very tricky to determine whether or not someone has a firmly held belief that COVID vaccine is not something that they can have as a result of their religious beliefs. There has been, in my experience, a lot of template statements being circulated within this region from some website or group that has outlined various reasons that vaccines are not allowed as a result of religious belief. But it's clear that when someone gives a template, downloads it off the internet and gives it in, and then is then unable to explain in their own words why a vaccine is against their religion, that's when a lot of my employer clients have said, no, we're not going to accept that this is a valid religious exemption. So there are some that I've seen that do appear to be a sincere belief, and others that appear that they've just downloaded something off the internet and are not. Under the mandatory policy, we don't yet have any case law regarding whether or not no civil case law. So that means nothing in a non-unionized environment where an employer has terminated an employee because they haven't been vaccinated on a for-cause basis. So one of the questions we have is that if someone doesn't comply with the mandatory vaccination policy and the result is then a termination, is that termination for cause or without cause? I just saw yesterday that the City of Toronto has terminated, I think, 300 or 400 employees because they failed to be vaccinated by January of 2022. It doesn't say whether or not they've decided to do it for cause or without cause. I expect if they're going to terminate 300 to 400 people, they likely were not going to be paying out packages to people, so that those employees will likely be terminated for cause, meaning that they have failed to comply with a policy, that policy will be deemed to be reasonable by the courts, and that it was something that they needed to comply with in order to continue with their employment. So we do have some arbitration decisions, meaning in the unionized context that have upheld that mandatory policies are appropriate as a result of the manner in which the work is performed by the employees. So arbitrators are really taking a look at what do these employees do? What's the risk to those particular employees? And is this policy reasonable within that workplace environment? Healthcare, I expect, will be deemed to be reasonable. We know that security, there was one security company that had many employees going to different locations and working out of those locations in person. That was deemed to be a reasonable policy to protect the health and safety of both the employee as well as others who they interact with. So we don't yet know what the courts will say regarding whether or not you can terminate for cause or without cause. I have had some employers who have put in a mandatory policy, which wasn't directed by the government to do so, but chose to do it on their own. They had pretty much 98% compliance with the policy, but at the end of the day, they did need to terminate 2 people. They decided, instead of pursuing a for-cause termination, that they would pay out those 2 people. In their case, we had a valid employment contract that limited the employer's liability only to the Employment Standards Act minimums, and therefore, instead of rolling the dice and starting a court case about did the employer have cause or not cause, we decided, and they decided that they would terminate on a without cause basis, pay the minimums under the Employment Standards Act, and walk away. Now, again, larger employers with many employees who have to be terminated as a result of non-compliance will likely be more willing to roll the dice, claim it's a for-cause termination, and wait to see what the courts say on that particular workplace and policy to see whether or not it's reasonable for an employee to have had to follow that policy. The other one that I have implemented for employers is a vaccine policy with a waiver. So in that type of policy, it's sort of like an opt-out regime with added protection. That's how I sell it, is that obviously you are asking everyone to be fully vaccinated. You'll have exemptions for people who have either religious or medical reasons, or the employee can opt out and they sign basically like a waiver saying, if I'm not going to be fully vaccinated, then I am going to agree that if needed, additional safety precautions, additional PPE, additional requirements might be placed on my employment because I'm not vaccinated, and including I'm going to submit to routine rapid testing. So a lot of policies, obviously the point of a policy is to ensure heightened safety within the workplace. So heightened safety through vaccination is the main goal. But if someone is exempt for medical reason, well, what are you going to do for that person in the people who are working with that person to make it a safe workplace? And then, what most employers are doing is that they're doing routine rapid testing. And so if someone has an exemption, or if someone decides to waive a vaccine, is that they are going to agree to submit to doing rapid testing. We do know from the Ontario Human Rights Tribunal that people with an exemption, those rapid tests should be paid by the employer. And thankfully, the Chamber of Commerce is assisting with rolling out these rapid tests available to businesses. So that's been very helpful so far, and hopefully businesses will still have access to those tests going forward. But rapid testing has been something that they'll implement. So if you're not going to get a vaccine, we'll test you 2 times a week just to ensure that our workplace remains safe. Now, if that non-vaccinated person without an exemption decides not to do the rapid testing or refuses to do so, then again, in the policy, there's some discipline. So, if you're not going to follow the policy, you might be put on an unpaid leave of absence. And again, if in their contract, you have a provision that says that you can be placed on an unpaid leave of absence, then you're covering your bases off from any claim against constructive dismissal. And then the very last one that employers have implemented is just a general statement. So it's really not, it's a policy that says we support vaccination in the workplace, and we hope that all employees get vaccinated. And in some cases, an employer will give an incentive to people who are vaccinated or who get vaccinated. They will have a policy that supports, time off in order to go and receive a vaccine. Again, with an incentive, if someone has, a religious or medical reason where they can't, they should still also be entitled to any incentive. Just because of their religion or medical reason, they shouldn't be deprived of some sort of benefit that the workplace is providing. So that the last one, it's obviously doesn't have much teeth to it, but it may assist in getting people to want to go and get a vaccine if there's some sort of incentive provided for that. So we're a little, I'm ending a little bit early because I know lots of people will likely have questions regarding lots of the topics that we talked about. So Caitlin, I don't know if you want to moderate those questions.
Yes, thank you so much, Megan. That was so relevant, especially with all that we're going through right now. And I'm sure very helpful for many of our members. If you do have any questions, please feel free to use the chat box, and I'm happy to ask them out loud and moderate them. Or I could even unmute you if you would like to ask the question verbally.
I always find that might be easier.
Yeah, if you want to just try raise your hand, your virtual hand through Zoom. or just send me a chat. Any questions?
Everyone knows all of this because we've been dealing with it for the last year and a bit, going on 2 years.
Absolutely, but it is a definitely a great opportunity to ask the expert here with any questions that you may have.
I'm okay with no questions. This is
well, maybe let's try and come up with a question here. I know from experience that a lot of people are still kind of questioning or worried about this new, you touched on it briefly within your presentation about the new right to disconnect. Now, is there, I guess, any recommendations you have, or like, what do you see the main problems being with from an employer perspective with that new policy?
The one thing about the policy, obviously, so we're going to have this policy that you right to disconnect it, and after your set hours of employment. One thing that the Employment Standards Act includes is a 3-hour rule. So if an employee is required to attend to perform work, and it's less than 3 hours, they're to be paid 3 hours. So we got that 3-hour rule. If someone's normal work hours are 9 to 5, and an employer calls them after hours to do work, you're risking the 3-hour rule, especially because if you have a set work hours. So for a lot of salaried employees, what's important in a contract is to say that they are to be available out of hours, that their compensation, you get their compensation is X per year, but that compensation is, your hours of work are regular office hours plus any hours outside of that in order to respond to operational needs. So we're making it very clear that your time is flexible, and it doesn't to avoid that 3-hour rule issue. It's a little bit harder with hourly employees that have a very set schedule, that if you're going to be asking them to do work outside of that schedule, we have to be wary of both this policy as well as the 3-hour rule.
That's great. Yeah, I think that at least from what I've heard from a lot of our members is that's the hot topic right now. So thank you for expanding on that.
Okay, so I have a question here. You can see it.
Yeah.
Can an employee refuse work under the Occupational Health and Safety Act if there is no vaccination policy in place, or if there is no contract regarding this? Okay, so an employee, in order to refuse work under the Occupational Health and Safety Act, they have to actually be at work and identify a safety concern. So an issue I've had with an employer is that someone was working from remote and did not want to come back in the office. Well, and they said, there's a safety concern. Well, you don't know if there's a safety concern when you're not there, right? Just because there's, there's COVID doesn't mean there's a specific safety concern, because many people have continued to work within a workplace environment with following either the provincial or public health guidelines. So long as the employer is continuing to implement social distancing, masking, sanitizing, all the things that we've been told to do, if they are doing that, then vaccination policy is not something that is a requirement through public health or the province. So no, the person cannot refuse to to come to work because there's no vaccination policy in place. Obviously, the best protection for an employer and employees is to have, to mandate vaccines, because that's what it just limits for employers. It limits any liability of a potential claim that someone got hurt on the job. But there is no requirement to have a policies in place. The government has not, implemented that. So that is not something that an employee can say is a occupational health and safety concern if there isn't one. Obviously, if you have a vaccine policy, obviously you want to make sure that in that policy it states that all new hires are to be vaccinated, or it's a condition of employment that the person be vaccinated. And employers can do that with new employees. It's just the imposing a vaccine policy on your current employees where there wasn't previously not a term of their employment to have a vaccine. Okay. How do you keep an employment contract current for employees that were hired many years ago, like for the termination clause? Yes. Okay. Okay. Sorry. How do you keep an employment contract current for employees that were hired many years ago, like for the termination clause, temporary clause, and unpaid? Okay. So in order to update a contract of employment and changing the terms, because likely a contract from 5 years ago, or if an employee doesn't have a contract, is likely out of date. The law has changed significantly since 2020. And so we are recommending to update contracts. There is a nice way and a not nice way. The nice way is because you're changing the terms, you have to give the employee new consideration. So in contract law, you offer, there's an acceptance, and there's some sort of consideration flowing between the parties. In order to do that, in order to introduce a new contract that has the good provisions, you have to give the employee something in return for signing that new contract that would likely waive some of the rights that they have had before or change their rights. And so what that can be is a signing bonus. It can be an increase in pay. It can be an increase in vacation time. But all of those things that are going, or the thing that you're thinking about to give to that employee has to be something that they're not necessarily already entitled to. So, if you have an employee who's moving from 2 weeks vacation to 3 weeks vacation because of the Employment Standards Act, that's not new or fresh consideration. It's something that they're already entitled to. A lot of employers will say to me, okay, well, by how much? How much do I need to do? Sometimes what we do have a court case that said, the courts aren't going to look or get into an analysis of what is, significant for one employee versus another. If you're going to give them a $500 signing bonus, that might mean a lot to someone. It might not mean that much to someone else, but we're not going to evaluate that. If someone decides to accept the $500 in order to sign the contract, then that they've done that. So that's the nice way. Give your employee something extra that they would not have already been entitled to in order to sign a new contract. The not so nice way. You evaluate what the Employment Standards Act notice would be. So let's just say you have an employee there for 8 years. They're entitled to at least 8 weeks of working notice or pay in lieu of notice if you were to terminate them, plus severance depending upon your payroll limit, which is if it's more than 2.5 million, then there's severance. But if we're just talking about payroll less than 2.5 million, and you've got an employee for 8 years, you would say to that employee, Joe, we're wanting to change we want to implement new contracts to outline the rights and responsibilities, so everyone's clear on the rights and responsibilities. And so we're giving you notice that your current employment with us is going to end in 8 weeks. But at that point in time, if you want to continue to work with us, here's your new contract as of 8 weeks. Review it. It's the same compensation. So you want to make sure you're keeping all the same terms, vacation, compensation, hours of work. And here's we're gonna offer you the same stuff after 8 weeks, but you need to sign this new contract. And if the person doesn't sign the contract, then they're dismissed. Now, you do that and you offer the same compensation, vacation, etc. Because if the employee doesn't accept those new terms or that new contract, then they can't make and you've already given them the Employment Standards Act notice that it's required. They can't then at that point in time allege that they're entitled to additional notice, because what you would argue as an employer is that, well, no, we offered you the same employment, same compensation, same vacation. We just modified some of the other, peripheral terms. You failed to mitigate your alleged damages by not accepting the new offer terms for continued employment. And in that case, though, their tenure with the employer would still continue from the original start date, but the new terms regarding termination, layoff, etc., would be included in the contract and would be then valid going forward. It's obviously not nice, because you do have to clearly state to that employee that their current employment is ending and will then continue under the contract, the new contract thereafter. Or if they don't accept, see you later. It's not very nice, but we do it quite often, especially since the change in the law since 2020.
I think we also have another question in the chat saying, is there a specific religion that suggests they do not want to receive a vaccine? And then why wouldn't we see any employee use their religion as an excuse?
Well, so what I have seen is, so the Pope has come out and said that there's nothing, the Pope, so Catholic religion came out and said that he was supportive of vaccines. So that one was kind of cleared. I have not seen any specific religion come out, like a main denomination or main following come out and say that. We do know that there is a church, like a particular church in this region, that is not supportive of vaccines, and it's unclear though whether or not it's not supportive of vaccines or not supportive of lockdowns, government interference, all of those things. Even if you are a follower of that particular church, you still have to identify how your religious beliefs, why they say you can't get a vaccine. So it is very, very hard to establish that. I've seen lots of scripture being cited as proof or to try to validate someone's not wanting to have a vaccine. So I have not seen any larger denomination or following say that. But again, the Ontario Human Rights Tribunal will recognize that there are different beliefs within a system of beliefs, and that it's personal in nature, and that people have tried to figure out a way to suggest that a particular belief is preventing them from a vaccine. Yeah, I'm sorry, I'm not very clear on this, because there's not a specific religion, but people have tried to take certain things from that religion and as support for the reason not to.
Okay. And we have another question here. Yeah.
We have a mandatory vaccine policy in place. An employee is currently on 10 unpaid leave. Our policy states that they still remain unvaccinated after the unpaid leave, we accept it as a voluntary resignation. Yeah. Are we able to do this, or do we make a choice to terminate? This employee will likely claim, no, I did not resign. I was constructively dismissed. Right? You've imposed a policy on me. I don't agree with it. It's a change of the terms of my employment agreement. I didn't have a term that required me to get vaccinated. Any deemed because basically you're saying you're deeming her to be resignated, to have resigned. He or she will come back and say, no, I didn't resign. I was constructively dismissed. So I think you're at a wait and see what this employee does. They may not take any action. You can claim that they resigned. Likely they will dispute that. And at that point in time, they'll say, no, I did not resign. I was just constructively dismissed, and I'm seeking my notice. Now, at that time, you can say, well, you've already said that they've resigned and no notice is owing. You would probably take an alternative approach and say, well, if they did not resign, we had cause to terminate. But again, you're now getting into an evaluation of, will a court uphold your policy? Was it reasonable? When we look at your workplace environment, did you need a mandatory policy? I don't think that a court, like my office environment, I don't think a court would uphold a vaccine policy. We are able to be socially distanced. We wear our masks. Our workplace, the work we do is not a high risk. I'm not working beside people on a line. I'm not in healthcare. So I really think that they're going to evaluate every workplace to see what type of work you do. Was it reasonable to mandate that everyone get vaccinated? And then, if it wasn't reasonable, then you're into the without cause termination. And so for those employees who are on an unpaid leave now, you should be considering what your potential liability would be for those employees if at the end of the day, a court or you decide that to make the termination on a without cause basis.
That's great. Thank you, Megan. I don't think that there is any other questions that I see right now, at least. So we'll give it maybe one more minute and we can wrap it up.
Siwan, are we able to get a copy of this recording or PowerPoint?
Yes, I did reply to that one. Please note that this session was recorded and will be uploaded to the Cambridge Chamber YouTube channel. So it will be available for you to review at a later date.
Thank you, Caitlin. I appreciate being invited to come on again. Unfortunately, I was hoping that most of this talk would be after pandemic, but we are still dealing with during pandemic. So if anyone does have any questions, feel free to contact our office. Myself and my associate Andrew, we've been dealing with lots of COVID-related employment questions over the last year and a bit, and we'd be happy to help anyone going further.
Fantastic. Well, thank you so much for your time today, Megan. It was wonderful and, like I said, so relevant with what we're living through today. So thank you so much for your time. And thank you all for joining us today.